Okay. Okay. Good afternoon, respected seniors and professional colleagues. I, C. Nitin Baradia, welcoming you all to the 17th series of this webinar on the theme Grow Your Practice, which is being organized by the Committee for Members in the Practice of ICAI. Dear all, under the leadership of our President C.A. Ranjit Kumar Agarwal ji, Vice President C.A. Charanjit Nanda ji, Chairman CMP ICI CA Dr. Rohit Rohatia ji, and Vice Chairman CMP ICI C. Umesh Sharma ji, Committee for Member in Practice is working really hard for the upliftment of the profession and growth in the practice for the members. Apart from organizing regular webinar like this, Committee for Members in Practice is hosting events like Practice Ki Pathshala, and I'm delighted to share with you all that today, under the leadership of CA Rohit Ruatia ji, fifth batch of Practice Ki Pathshala has begun at the Center of Excellence Jaipur, and fourth batch has begun in the Center of Excellence Hyderabad. So, dear all, it's really a great honor for among us to have such persons who are working really hard for the upliftment of the profession. Yes. Now, apart from this, committee is also coming up with various audit tools like practice management softwares, audit tools, and various schemes for the members for like insurances and health checkups. You are requested to go through the website cmpbenefits.ici.org to have a complete walk around of all the schemes available for the members. Now I take the opportunity to call upon CA Rohit Ruatia ji for his welcome address. Sir, please.
Thank you, Nitin ji. Very respected speaker of today's session, Gopal Krishna Raju ji, Ankit Garg ji, and the team of CMP. My dear professional colleagues, a very good afternoon to one and all. I welcome all of you in this 17th event, 17th webinar on Grow Your Practice. And I can understand that it is a busy season in terms of the ITRs are concerned. But at the same time, the Committee for Members in Practice is continuously focusing on new avenues, new areas where we can have professional opportunities. And today's session on the Mediation Act, the professional opportunities in the Mediation Act for the professionals, has to be dealt accordingly. So I'm sure with the kind understanding and the knowledge of our Honorable Speaker Gopal Krishna Raju ji, our members will definitely able to gather certain insights and intricacies of this Mediation Act. Of course, our MOC of today's session, Nitin ji, has already shared a lot of initiatives done by the CMP committee. But along with the CMP committee, I would urge all the members to kindly visit the ICI.org website regularly for the recent development and the updates of the profession. And also we can visit the Tender Monitoring Directorate website where we can see all these things, related to the tenders opportunities which are available in the profession in the country. And also we have developed a complaint platform where we can put the complaint related to any of the organization, any of the CA firms who are putting below the minimum fees, and institute by its committee, Tender Monitoring Directorate, putting restrictions on such kind of firms who are degrading the profession, who are putting low cost in the various tender authorities. Secondly, we have developed a utility for the minimum fee. The minimum fee calculator has been developed by the institute on this TMT directorate only, where you will be able to give the quotation to your client on the basis of the recommended scale of fees proposed by the institute, and that will generate a pro forma invoice in which the category of services which you are providing, you will select the category of city, class A, class B, class C. You will select the services offered, and then enter your detail, enter your client detail, email ID, mobile number, put submit. A window will be there. It will be a PDF file, and it will be a quotation will be there. Then in the narration, it will be mentioned GST extra, and this is proposed fees recommended by the institute. You can give to your client and negotiate and bargain accordingly. So a fee calculator has been developed under the TMD, because I am also heading Tender Monitoring Directorate. So it was recent update for all of you. Along with the various tie-ups which the CMP committee is doing, kindly visit the cmpbenefit.ici.org regularly to see, because we are regularly posting the new tie-ups which are relevant for our professionals. So every week there is another new tie-up for our professionals, and there are more than 100 tie-ups related to our office work in which we are working and focusing on the capacity building of the professionals. So if you really encourage and if you really see the benefits, your capacity in the office will be certainly beneficial. Along with these CMP benefits, we are having a practice management software which is being proposed, which is being given to all the professional CA firms at free of cost, developed by the institute, in which if you are adopting this practice management software, your office will become paperless. Once, yes, certainly you need to have that much infrastructure, that much human resources in your office to use it, but definitely by using the practice management software, your overall office system will become really automatic, and no paperwork requirement will be there. Another recent tie-up is done with the company Any Audit, which is providing audit tool in relation to all types of audit, which is helpful for all of us in our routine practice. And it is very interface is very user friendly, and you can pick up the data from the tally and any accounting software and migrate to the Any Audit tool. If you want to do the company audit, tax audit, or any other internal audit, any type of audit you can do, you can make the framework and do the audit using the audit tool, because by which we are increasing the capacity of the professionals. So a lot of initiatives are being taken. Practice Ki Pathshala is running over here in Jaipur and Hyderabad COE, and 6 Practice Ki Pathshala have been organized. The next Practice Ki Pathshala is going to be happen on 2nd to 4th of August in both Center of Excellence Jaipur and Hyderabad, where again 3 days program is being organized for the very first time in this committee, in which all the professionals come together, not to learn any academic part, but to bring the network, to build the network, to discuss the various professional opportunities which they are doing in their local areas, to collaborate together, to make a team, to make an alumni, to understand the feeling of togetherness by doing a residential program here. 30, 40, 45, 50 people are staying here in Hyderabad and Jaipur, building their network, and they are growing fast. So these are certain initiatives which the committee is regularly taking. I am always available. If any member has any kind of suggestions, they can always mail me or WhatsApp me for any other issues to be taken forward. So I will not take much of the time today. But again, once again, thank you to honorable speakers of today's session, the MOC, Nitin Bhadia ji, and the professional colleagues for attending the program. Thank you very much. Jai Hind, Jai Bharat, Jai ICA.
Thank you, sir, for your valuable words of wisdom, and thank you for sharing with us all the initiative which has been taken by the ICI. Now it's time to go ahead with our today's session on the role of CAs under the Mediation Act 2023. Dear all, the Mediation Act 2023 has come up with a lot of professional opportunities. And in order to convert such opportunities into reality, we are honored to have among us our eminent speaker, CA Dr. Gopal Krishna Raju. Though we know very well Mr. Gopal Krishna Raju ji, and I think we need a particular session to discuss about the profile which he has. But I'll sum up his profile in a few words. Gopal Krishna Raju ji is a practicing chartered accountant, registered insolvency professional, registered valuer, and an arbitrator from Chennai. Gopal sir is the tax assurance and restructuring partner of Messrs. K. Gopal Rao and Company. Sir has served consecutive 3 terms of 9 years from 2010 to 19 as Southern India Regional Council member of the Institute of Chartered Accountants of India. Sir has been awarded honorary doctorate honoris causa in the governments of GST in government sector by St. Mother Teresa University, Melbourne, Australia. Sir is an independent director in the various state public sector undertakings of Government of Tamil Nadu. Sir is a technical reviewer in the Quality Review Board constituted by central government under the CA Act. He holds various qualifications other than the CA. He is also an author to Standard Costing and Variance Alliance for Professional Students, First Lessons in the Information Technology for CA Students, The Real Value, the First Business Value Must Disclosure Next. Sir has also been nominated by various academic boards of various university. He's a passionate writer on technology and taxation in numerous journals and newspapers. He's a columnist in the Tamil Daily, the Hindu Tamil, and a weekly Tamil magazine, Nam Vikatam, and Puthiya Talai Murai Kalvi. As a versatile speaker, Gopal sir has addressed more than 7,500 meetings on the income tax, GST, and investor awareness programs to various forums, including central and state government departments, professional bodies, Chamber of Commerce, industry, and trade association in both English and Tamil. Sir, we are deeply honored to have you here, sir. It's really my privilege to welcome you, sir.
Thank you very much.
No, sir. It's all yours, sir. Thank you.
The respected Central Council member and chairman of CMP, Dr. Rohit Ruatia, the kind of work under your chairmanship and ICA has been doing is fabulous. The various initiatives, sample of which you have mentioned, that itself is an enabler and a lot of supporting and hand-holding exercise ICA has been doing parallelly. This program is an example of this committee, how for members in practice, a subject like this, especially on the developments that has been happening. There were times, maybe 3 or 4 decades back, that a chartered accountant means is a tax auditor, he is an assurance or balance sheet sign करने के लिए ही पैदा हुआ है. But the kind of developments that has been happening, wherever now money is there, chartered accountant will be there. And not only where money is there, where money related disputes are there, comparable to, with the due respect and regards to our professional brothers in legal profession, a chartered accountant's role will be more suitable because a CA can understand money related litigation much better. And ultimately, when two sides, there are tough and tussle. एक साइड कहेंगे मुझे 120 crores आना चाहिए. Another side, they will say, no, I will only have to pay 90 crores. So the gap is 30 crores. Now, how do we understand this? And this term mediator, for Indian born children, and Indian parented children, ये तो new word नहीं है. Especially as a child, whenever we have faced certain very hostile environment, we will go and surrender to Dadaji, ya Dadiji, ya Ma, where they will be the spring cushion, the mediators between us and the issue. And mediation maybe suna nahi hai at the younger age, but hum sab we have felt it. We have a feeling about it, what mediation is all about. And at the end, when either our Ma or Dadiji or Dadaji, they amicably settle the issue, the kind of affection and love and the family harmony is totally different. The same is the case if it is a commercial dispute. Keeping all this in mind, maybe when this topic was read, that chartered accountants, role of CAs, mediation, ये क्या करेंगे chartered accountant mediation पे? That is why I said money and money-related disputes, CAs are the best guys. And that's where we are going to discuss today. There is a new Act 2023, the Mediation Act has been brought out. But of course, हमारा बड़े भाई हैं, हमारा बड़े sisters हैं, legal profession की brothers and sisters हैं, they take the lead there. But काफी जगह वही भी है. We have space there also, where when money is discussed, our legal brothers and sisters, they invite us. Oh, brother, why not you come here and help us and understand this commercial dispute so that mediation can happen. Mediation is a conciliation. We are not new to this word called conciliation. Add 2 letters before conciliation. Reconciliation. Reconciliation pe chartered accountants are the best. So whether it is a GST reconciliation, TDS reconciliation or bank reconciliation, हम काफी जानते हैं. So with this brief background, I will take along with me my brother CA Nitin Baradia, the moderator of today's session. Thank you very much, Nitin Bhai, for that wonderful introduction and for being moderator of today's session. So I will hand over the safe hands in you, and you can lead this chariot and I'll be behind you, and together we will suffer करेंगे. Thank you very much.
Yes, sir. So, sir, there are some questions which I'm putting for you.
Yeah.
So, sir, what is this mediation, sir?
Well, so let me directly go to the subject.
Yes, sir.
2023 Act. This Act came on 14th of September 2023. It has been brought by Government of India and it is already in practice. So mediation, mediator, settlement, agreement, many things we will understand. But before that, I will just share with you the screen. This is the Mediation Act which came on 14th of September 2023. Ispe, there is a section called 3. Normally section 2 used to be the definition section, but here section 2 is about application. I'll come to this, where this mediation you can apply. Can cross-border mediation also can apply? Actually, answer is yes. So Jagada within the state, within the country, country to country, because nowadays my supplier will be in Australia, I am in Mumbai. So Jagada देश के आगे भी होती है. Okay, so then can we have a cross-border mediation also? So for all this scope is there. If you look at it, okay, this act shall apply where mediation is conducted in India and there is an international arbitration. So it will be conducted here, then this act will apply. But international mediation. So quite a very wide spectrum they have given. So now you will ask, okay, mediation kya hai? Okay. So this is a process and it is an inclusive definition. So exhaustive nahi hai. So you can add further more. So it is a process. And we have experienced this mediation in our families also. So within, so always Indian husbands are mediators only between wife and mother. So therefore, for Indian husbands, you need not teach them how to be a mediator because we can't either take this side or that side. So we have to be a mediator. So yahan bhi sunna padega, wahan bhi sunna padega, and then we have to come to a settlement. So a mutual settlement. So mediation includes a process where referred to by an expression mediation. So there will be an agreement. I repeat, there will be an agreement. And pre-litigation mediation. So jagade ke pude. So it is before that. Okay, let us not go to court. Before court itself, we will amicably settle. So that is what courts also prefer. Why you are filing application and मेरा सर का दर्द बढ़ रहा है. Don't pile all the already lakhs of cases are there. Don't pile it up. So झगड़ा ये है ना आपस पे you try to mediate it and settle it. At the end of the day, judge gives only judgment. Okay, it is not settlement, it is judgment. So he only judges. Sometimes the judgment it does not say it is a correct statement. Okay, judgment, whatever the judge writes, it is not a correct statement. It is only his judgment, his subjective. So naturally, why everything you come to judge? It can even be, judge is also a human being and a mediator is also a human being. And already a chartered accountant is well experienced, seasoned by various process, regulated process. So therefore, a pre-litigation mediation, online mediation, no, this online dispute resolution. We are not going to hug the parties. You come, I will hug you. I will hug you. So physically, we don't need to be present. इस साइड सुनना है, उस साइड सुनना है. So इसके लिए online काफी है. Okay. Community mediation is very interesting. So today, today we have this gated community. So 40 flat होगी, apartment होगी, 1000 apartments होगी, 2000 apartments होगी, and the moment numbers are even 10, 20, jagada will be there. Some jagada, okay, your two-wheeler parking, four-wheeler parking, yaha, waha. So many things will be there. This community mediation. So accounts nahi gidiya, secretary, treasurer, appointment, president nahi bolta hai. So many things will be there. So now all of us, we live in metro, so we know what this community jagada is. It will be very, very small things. So for all this, going to courts, even yesterday, day before yesterday, in my office, there was one 48 apartment case. In a year, they collect maximum 12 lakh rupees. The treasurer has not submitted accounts for 3 years. So everybody are boiling. What is this? Accounts are not submitted. We will remove, we will file a police complaint, that, this, that, boot, everything. So community mediation is also required today. So everything going to police station and courts. What court will do? Again, the same what mediator will do, same he will also do. So let us not waste the honorable court's time. So we have to value the time of courts. The legal system, we have to only value with the respect of valuable disputes. So not all the chota mota disputes. So it doesn't mean that mediation is only for chota mota. So even community mediation, they have brought it. While defining mediation, they said community jagada also let it be done here. Okay. So then conciliation. Now please understand conciliation. So we use a word called arbitration and conciliation. Okay. Arbitration, mediation, conciliation. Arbitration is a different process. Mediation is a different process. Because an arbitration is almost like a judging process. Okay. So almost like a judging process. But in conciliation and mediation, there is a written agreement. I will agree to what the mediator will hear this side, this side. Okay, I'll give you a solution. You agree? I'll give you a solution. You agree? Okay, sign. Both of you sign. And they are not supposed to go to court once mediation is done. That is why courts are very much willing to give it to mediators. You take it. You hear both sides and come to amicable settlement. Put it in writing and give it to me. My job काफी easy हो जाएगा. So mediation is actually a process that will facilitate the adjudicating process. So it is a sub process. You can say it is a judicial process, a legal process, but it's a sub process. For example, so there is a contract dispute. Okay. So we have an insolvency case. Now, what is insolvency case? Bank of Maharashtra, I have borrowed 800 crores. Now I have only 150 crores. Kahan gaya? Bona fide money is lost or there is a mala fide intention. Now, the question is, this guy will go to IBC and he will file an application that insolvency, this company is under insolvency. Now, the problem is there will be a lot of creditors who will put claims. Now, इसमें प्रॉब्लम रहेगी. There will be a creditor who will put 80 crore का claim, but documentation will be there only for 30 crores. Now if you permit, if you allow only 30 crores and reject balance 50 crores, he'll again go to court, and court का time बर्बाद होगा. So what to do? The claim related part alone, he will say, okay, mediation के पास जाओ और settle करके आओ. So what is the actual claim? 80 crores, 80 crore है, 30 crore. No, 40 crore. Okay, agreed both sides. Okay, then put again. So now money is involved here. So money related disputes, otherwise called commercial disputes. So I will come to that particular word, Nitin Bhai, again. What is this commercial disputes? Or an expression of similar import, whereby parties attempt to reach an amicable settlement. This word is very important. Actually, you will not come to this word called amicable settlement in arbitration. Never. Mediation is the only word. Conciliation is the only word. The word amicable settlement of their dispute with the assistance of a third person. This third person is the Krishna Bhagavan. So he is the mediator. Okay. So now you may, all of you have our chartered accountants will have a question mark here. Oh, exam pass करनी है. कुछ whether CA काफी है, whether experience चाहिए. I'll come. Don't worry. Whether a chartered accountant can become a mediator, we'll come to that. Okay. So referred to as a mediator, and who does not have the authority to impose a settlement upon the parties to dispute. He cannot direct, hey, 80 crore pe 40 crore le lo. I cannot direct. I can only tell. See, these are the documents you have given. You are asking for 80 crore. Document पे 40 करोड़ ही है. कैसे 80 आएगी? कहाँ है 80 करोड़? So I cannot direct them, but I can mediate. It is not convincing. It is not directing. It is between convincing and directing, mediating. Actually, to understand what mediation is, we have to learn from Indian husbands who live along with mother and wife. They are the best mediators in the world. The world, Indian husbands are the best mediators. Okay, good. Over to Nitin Baradia.
True. So you have greatly explained the same, sir. Husbands really play
I'm
a
sure
major role.
each of the Indian husbands, if they read the
Yes, sir.
Mediation Act, ये तो हम तो daily कर रहे हैं. Okay.
So sir, what we have understood from here, mediator has to create a balance, sir, between both the parties, sir. He cannot direct, he cannot force anyone, sir. He just has to create a balance so both the parties are happy, sir. Yes, sir.
Actually,
No.
the point here is, if you listen, 50% of the problem is settled.
Yes, sir.
Suno. Even all the Indian wives, how they will call, Suno ji. Listen. First of all, whatever I am saying, you listen. You don't shout first.
Yes,
Suno ji. This is the word our Indian wives, they use. So Suno ji. So listen. If you listen itself, 50% problem solved. Listen to what Amma says, Ma says. Listen to what wife says. 90. Oh yeah, my son is very good. He listens to me. Now my husband is very good. He listens to me. That's all. 90% problem solved there itself. Okay.
true, sir.
Only thing
True.
is, you should not go to wife and say, no, Ma aisa kahe, you do like that. Then the problem is the Mahalakshmi will become Bhadrakali there. Okay.
Great. And sir, the scope of this mediation is, sir, endless. It is applicable to each and everything, sir.
Good. Actually, this is where I want to come. It's called the list where you can actually mediate. So for that, I'm going to take you to a point, a terminology called commercial dispute. Okay, commercial dispute. Because if you look at it, so the act shall apply to mediation with respect to commercial disputes. Because the word dispute means commercial disputes. So for example, if there is a dispute, family dispute, husband and wife dispute, you cannot go to mediator. Okay. For that, you have to go to a commercial family court, and there will be a family court mediator. That's a different segment. This is a commercial dispute, paisa ka dispute. Okay, now this commercial dispute is not defined here. It has to go to Commercial Court Act 2015. So I am now bringing Nitin Baradia's
Yes.
kind attention to
Yes, sir.
the 2(1)(c) of Commercial Courts Act, that is called commercial dispute. This will give us an idea. Oh my God, all these disputes come under mediation. Amazing. Look at this. Ordinary transactions of merchants, bankers, financiers, traders, importers, exporters, maritime laws, transaction relating to aircraft, sale, leasing, financing, goods carriage related contracts, construction related and infrastructure related contracts, immovable property agreement related disputes, franchising agreement related disputes, distribution and licensing related disputes, management consultancy disputes. Oh, मैं M&A का agreement डालने के लिए, what is this? The delivery is not poor, delivery is not correct. JV agreements, shareholders agreements. Oh my God. So यही कुछ हम कर रहे हैं. So these are all we do. But when dispute comes, they go to our brothers and sisters who are legal professionals. Now tell me, Nitin Baradia, who are the best guys? Because the Jagada will come not between shareholders, but between shareholders for money.
Yes, sir.
Joint venture agreements, Jagada will not come between the joint venturers, but money related transaction only. All Jagada will be money transaction only. If other than money transaction, emotional transaction, then it is not mediation. They have to go to criminal law, code of civil procedure. Now to Bharatiya Nyaya Sanghita aa gaya. Okay, so that law only will take care. But commercial disputes, okay, the picture abhi baki hai. The commercial dispute list is still bigger. Oh my God, is it so? Subscription and investment agreements, outsourcing services, financial services, partnership agreements. My God, what a scope! What a scope! Now, we can actually put a board. यहाँ सब झगड़े का solution मिलना चाहिए, मिलेगा, आइए. Actually, a chartered accountant can actually earn more than doing a tax audit and झगड़ा settle करिए जी, मैं कुछ भी fees देने के लिए तैयार हूँ. You ask for tax audit fees, he will say, sir, 2 years later I'll give. But झगड़ा के लिए fees he will give immediately, even advance he will give. Technology related agreements, IPR related agreements and Jagada, an agreement for sale of goods and provision of services, GST related goods and services, oil and gas related, natural gas related agreements, insurance and reinsurance related agreements, agency agreements. My goodness, what a list. And all this come under mediation.
Very
Yes.
exhaustive list, sir. Very exhaustive list, sir.
Hmm.
So moving ahead, sir, I'm placing another question before you. Sir, in India, how government of India has taken legislative measures to promote the mediation in the country, sir?
Okay, so if at all we are we understand that okay, mediation abhi paida hua hai. Oh, only September 14th, 2023 is the date of birth for mediation. Before that, mediation was not there. No, it is not so. Already in various acts, mediation is there, maybe in a different avatar. So I'll just share with you the different avatar with respect to that. So I'll just share with you one such thing here. I think it's the list is here. So not this. These are the sections where already mediation is there in our various laws. What are they? 442 of the Companies Act, where it provides for referral of company disputes to mediation by NCLT. So you can ask, board of directors, sir, दुख रहा है, it's very सर दर्द हो रहा है, हमको this problem we cannot solve it, go to NCLT, surrender कर दो. My lord, please appoint a mediator. He will appoint it. So you have a provision, and under the NCLT rules also is there, and companies mediation and conciliation rules. Under that, you can ask for a mediator, and all the NCLT in our country, 13 NCLTs are there. They have a panel of mediators. Okay. And the Commercial Courts Act 12A provides for pre-institution mediation in commercial dispute. What is pre-institution? Before you file an arbitration, why should we go for an arbitration? Let us try mediation. Now I want to make one more here. See, there are centers called mediation centers in our country. I repeat, mediation centers. In every court complex, there is an arbitration center, mediation center is there. Especially today, there are very big family businesses are there. So, generation 1, they would have toiled very much and they would have amassed the wealth. Generation 2, generation 3, they are the kind of sizes, acres, hundreds and hundreds of acres of property, thousands of crores of money, okay, called an assets. Now, children will be there. They will be divided into two sides, one group and another group. Now, which assets has to go to whom? Now, this is what dispute is this? Is it a family dispute? No, it is a commercial dispute. Why? Because they want to do a business. These people also want to do a business. See, it is not that they are claiming, if they are claiming as a matter of birthright, then that's a different thing. That actually there is a running business. There is a fleet of companies. There's a 4, 5, 10, 40 companies will be there, running companies. 40,000 employees will be there. You cannot disturb anything. But I am one brother. That is another brother, 3 brothers. We are not together. I want one business vertical. He wants one business vertical. He wants another business vertical. Now, what kind of dispute is this? It's a business dispute. It's actually apas kama. So we will do a valuation, and then we will say mediation, sign getting agreement. 1/3 I will take, 1/3 he will take, 1/3. Now kiss 1/3 is mine. The kiss 1/3 is unka hoga. So kaun sa business main lunga, kaun sa business wo lega. So this is where, so going and fighting with each other, and then here what evidences you will put against them? Nothing. No, he has taken my share. This is where mediation is required. So, and wahan paisa jasti hai, adhik hai. And chartered accountants can do a very good role. Say, I know what you are doing. I know your plus and minus. I know your plus and minus. Come, sit. What do you want? You want your business? Which business you are strength? Okay. Let us see the net worth. What you are capable. You do this. We will have an agreement. Now, usme jara adhik, someone will get extra, someone will get less. So that difference, we have to tell those who have got higher, okay, that you pay to him in cash or in kind or some other property you give. That's a settlement. This is actually for the betterment of the business, going concern. So it is not a family dispute. It is a business dispute. People want to carry on business. So it is a pre-institution mediation in commercial courts. And RERA pe, amicable conciliation of disputes between promoters and allottees through dispute settlement forum, set up a consumer association, promoter association. It's already there. So mediation is already there in various laws. Only thing, we need mediators. We need qualified mediators. Now you can ask this question: who is a mediator? What is the qualification? Is there anything mentioned, anywhere mentioned? And is there any time limit for mediation? Can mediation go for 4 years, 5 years, 10 years? Because you go to court, whether time is fixed, no.
No more time limit.
We may not know. But like Damini movie mein, he will say that Diol will say, Tariq, that alone is confirmed, but insaf nahi milega. Okay. So then in Consumer Protection Act, reference of a dispute to mediation as an ADR mechanism for consumer mediation cell at each district commission, state commission, and national commission. You have a process. In MSME, the delayed payment, you can go for a conciliation when dispute arises on payment on MSMEs. You have the state conciliation council, which will take the complaint and they'll say, okay, kitna goods delivery kiya, kitna goods liya, okay, whether evidence, okay, then why are you not paying? Should you have to pass an order or you want to settle now itself? So before it goes for samadha, so there is a conciliation process is there. You need not go to court. Why we should jagada karne ke liye court jane hai? Mediation is the best process. Mediation is not, and most of the 90% of the jagada, when it goes to police station, people will say, this is a civil, 90% of civil, police station pe mediation hi ho rahi. So this concept is already in practice in our country. We are 142 crore population, and mediation, without the name mediation, it is happening right from family till police station, and in all these sections it is happening. Only thing is now for commercial disputes, we are going to have a formal method, and section 4 industrial dispute also, we have authorized the appropriate government to engage persons and for discharging the responsibility of mediating and promoting settlement of industrial disputes. That is also possible. All these are already there in our country in various laws. Now you have a Mediation Act. Now what is so special about it? Now these are all the respective mediation in the respective act. Now for commercial disputes, you have a Mediation Act. Good. So over to Nitin Bhai.
Yes, sir. So very small question. So what is the difference between an arbitrator and a mediator?
That's a good point. Actually, an arbitrator, arbitration is a process where it is an alternative dispute resolution. Okay, alternative. So how you can resolve a dispute? Can I only go to court and file an application in courts? And court will take its own time because filing of cases are there. So
Yes.
Tariq pe Tariq aayegi. So instead of going for courts, we can go for an arbitration where there will be a table, an arbitrator, and you can have a single arbitrator bench. You can have a tribunal arbitration bench. That means side 1 will have an arbitrator, side 2 will have an arbitrator, and both the arbitrators will appoint another arbitrator for the mutual hearing. And ultimately, or if there is a single arbitrator, he will hear both sides and he will give a verdict, a direction, an arbitration order, and that order is binding. I need not be reconciled with both. Whatever you want to argue, argue. Whatever you want to argue, argue. Whatever evidences you want to produce, produce. Whatever evidence you want to produce, produce. I will go through that independently. Almost akin to a court process. Almost akin to a court process. And I will pronounce an order. And that order is binding to both of them. Okay, binding to both of them. Or they can go for an appeal. They can go for an appeal. But in mediation, agreement will be signed that I will not go for an appeal. I'm signing it. I'm agreeing that my mediation agreement. Now, if I don't agree with the mediation agreement, there are exceptions are there. Quite an interesting. And I'm sure ICA will come up with a certificate course on mediation.
It should
come. Very soon it will come. And it is required. It is required. Okay. And it's such a lovely practice, because women chartered accountants also will prefer this. Because yahan jagada hai, but it won't be fight. It will be nice way. So motherly care, a grandmotherly care, a grandfatherly care in handling the disputes. Both the parties will be comfortable. And if you For example, you want out of 9 factories, sister and brother, they are fighting. Sister will say, "Mujhe 5 factory chahiye." Brother will say, "No, no, mujhe bhi 5 chahiye." 4 they are ready. One factory sister saying, "I want that." Brother saying, "I want that." This is the problem. Now I will ask sister, "Okay, you factory wo le lo." Then valuation jasti hai. So then the difference you pay cash to your brother. No, 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 I will not do that. Then how can there is no fair nahi hai na? So you have to be fair. There is something called fairness. Okay, fair value for financial reporting, fairness in judgment. So that is where the mediator have to explain. So what is the total asset value? 4,000 crore है. 4,000 crore पे 2,000 crores तुम्हारा भाई का है, 2,000 crores तुम्हारा है. But this one factory alone, if you take, it will be 2,200 crores. He will get only 1,800. Then extra 200 crores you pay cash. इंसाफी है ना? So काफी, it is fair. No, no, then where will I get the money? Okay, you give it in writing. The 200 crores you will give over a period of time, or paida karke main dunga. So I will earn and I will give. Something you have to follow, you have to bring a model. So that is where the mediators' experience, their gray hair will help them. Their experience with moving with people, their experience with, okay, factory chhod denge. Then you give this assets, you give this, these receivables are there. Let him collect that receivable. Or receivable tum chhod do. Factory tum le lo. Receivables, let him collect. Because you are good in accounting, you are good in business, you know accounting, you know the breakup of it. You are not only a legal person, you are also a finance guy. So slowly, a chartered accountant also takes the mantle of a legal profession, because we can understand law and we are experts in money. That combo is actually a deadly combo, very deadliest combo. Okay.
So, sir, one small question, sir. As there is no time limit in settling the commercial disputes,
No,
so
it is
how?
there. It is there. In Mediation Act, you have
Right.
a separate section
Okay.
where the time limit is mentioned. And the time limit is actually 120 days. Within
From the date of
time.
appointment of a
So,
mediator.
18. Yeah, I'll show you that section. That section is actually, where am I? Yes. So it's here. So this is section 18 पे मैं लूंगा आपको. So A has section 18. Time limit for completion of mediation. So this is a notwithstanding section. So कुछ भी कहें, कहीं भी कुछ भी कहें, anything contained in any other law for the time being in force, whichever, because so many, we have Partnership Act, we have Information Technology Act, so many acts there. Okay. Mediation under this act shall be completed within about 120 days. That's all. From the date fixed for the first appearance before the mediator, the first hearing. Because before that, a lot of agreements, lot of discussions will go on. The first hearing, from the first hearing, 120 days. Now, you can extend for another 60 days. So, maximum 180 days.
180 days.
Okay.
That's
So,
great,
that
sir.
means 6 months time. So, this is very, very critical. That means, can I pass an order beyond 180 days? No. No, that's not an order. It's not order. It is called a settlement agreement. Mediated settlement agreement. So, no order. In arbitration, order will be there. Direction. But in mediation, settlement agreement.
So what will happen
What
if yes, yes.
What a
So
nice word. What a nice word. This is actually nice act. Very good act.
very
It's a
good
nice
act.
thing. So nice act. It is not kadwa nahi hai. Okay.
So what will happen if I want to settle the dispute, commercial dispute, and other party was initially ready, they both appointed me, and now the other party is not coming, and this 180 days is also going to expire. How we can settle, sir?
Good. So mediation this is where the mediator has to have a timeline. So within he has to plan. So he has to study the case. discuss with them, both the sides. This is the settlement agreement. Okay. Now there is an initiation agreement is there. Settlement end. Initiation agreement is there. Now come here. This is section 4. Look at 4. This is starting point. Mediation agreement. This is started. Both of them should agree. I am the mediator. Agree,
Okay.
agree. You will agree to the whatever I say. You will also agree. And you will adhere to the timeline. Agree. Sign, sign. No, no, no. My now आऊंगा. मैं 6 महीने के बाद आऊंगा. Then you are not agreeing to mediation. You agree to mediation first. So a mediation agreement shall be in writing by both the parties. Between parties, and anyone claiming through them to submit to mediation all and certain disputes which have arisen and may arise between the parties. So they have to submit. यही हमारा झगड़ा है. Problem यही है. Okay, and we are ready for settlement. See, quite very interesting. A mediation agreement may be in the form of a mediation clause in a contract or a separate agreement. Okay, and it should be in writing, and document is signed by the parties, and it should be exchanged. No, 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 no. तुम्ही रखा है, मुझे copy नहीं दिया. No, वो kind of झगड़ा नहीं. Everybody should have a copy, and there must be a reference in agreement containing a mediation clause shall constitute a mediation agreement if the agreement is in writing and the reference is such as to make the mediation clause as part of the agreement. You can have a different agreement also. So there is a settlement agreement. In that, mediation will be one clause. Maybe it has been done in the previous part itself at the time of entering into a commercial contract. Yes. In that, you can have a mediation agreement. So you need not have a separate mediation agreement for mediation purpose. Like for nowadays, in partnership, you have an arbitration clause. Like that, yes, you can have a mediation clause. A reference in any agreement. So that means partnership agreement can have a mediation clause. Shareholders agreement can have a mediation clause. So not that only after Jagada comes, you create one mediation agreement. No, not required. Not required. Okay. Contains a mediation clause which constitute that it will be an agreement and there will be a mediator appointed and he will amicably he will go for it. See how it is. Nowadays, now henceforth, all partnership agreements, we must have we should mediation. Not copy paste with that arbitration clause.
Correct, sir. Correct,
we should always have a
mediation. Mediation.
paisa hai. So we have in our say firm एक senior partner है. So gray haired, we will tell him आपको practice नहीं करना. झगड़ा आएगी, उनको amicably mediate कर. And 4 वर्ष 5 वर्ष का tax audit fees he will get in one settlement. Correct, sir. And those people will pay because the झगड़ा तो settle हो रहा है. So this is very important. So let us now henceforth copy classes. Whatever is there, we'll put a mediation clause from September 23 onwards. Okay, from today, committee of members in practice. So as Rohit Ruwatia's chairmanship, this program is conducted. So from today, every one of us will take a role of CAs in Mediation Act. Every agreement, no arbitration clause. Arbitration clause, ho ya na ho, mediation clause, zarur ho.
Correct. And sir, everything gets over, both agreed, everyone signed the agreement. Now, after 1 year, if somebody wants to claim this order, or you can say a settlement agreement, can they do so before any court, before any panel?
I didn't get this question. What is this?
I'm saying, sir, that the entire settlement has been done. They have both the parties.
The settlement agreement is signed.
Yes, signed, sir. Now, after 1 year, one of the settler wakes up and want to challenge this mediation. Because, see, in our income tax proceedings, we give a statement before the officers. It's also before an oath. But he turned up after some time in saying that whatever entire proceedings was done under due pressure. And he retracts from his statements. So is there any possibility in this Mediation Act as well that then any party can turn up and say that the proceedings was vague and some like it was under my pressure, something like that, and I now want to challenge it?
See, this is a good question actually. This 19 and 20, they make this point very clear. So what they say, a mediated agreement includes an agreement in writing between some of the parties or all the parties resulting from mediation. Now, sometimes there will be 9 parties, 9 partners. 7 partners will agree, 2 will not agree. So, mediated settlement. Settling some or all the disputes and authenticated by the mediator. So, who are all signing? They are bound, they are obliged. So, where a mediated settlement agreement is reached between the party with regard to all, the same shall be reduced to in writing and signed. Why? This has to be registered. For the purpose of the record, mediated agreement arrived between the parties, okay, has to be, may at the option of the parties be registered with an authority constituted under the Act. So far, nobody is constituted. Okay, it may be registered. It's not a necessity, but can be registered. Okay, so provided the mediated settlement agreement may be registered within the jurisdiction of the court, tribunal, or competent to decide the subject matter of the dispute. Now, why this has been brought up is that point what you have raised for. Okay, that people who have already agreed should not go back. Okay, so please look at this point number 4. The parties may at any time during the mediation process make an agreement with respect to any of the, which is the subject matter of the mediation. So sub agreement also they can make. Any settlement includes a settlement agreement resulting from online mediation also can be brought under this. Now, what if there is no settlement? Now, once you have brought people under a settlement and it is signed, it is binding on them. I'll just share with you one very interesting point here, that 180 days, please look at this. Registration may be made by the parties within a period of 180 days from the date of authenticated copy. So I don't understand the reason for a registration when the word may is given. Okay, because once it is signed, it is obligation on both the parties. Once it is signed, it is obligated. So they cannot go back. So that means the entire process becomes a farce. So it is a legal process. Under the Mediation Act, he has appeared, agreed, signed. So going back is not possible, and court cannot take cognizance of it. Even if he goes to court and say, no, no, no. But the only thing is that the process followed by the mediator, opportunity not given, the documentation, what I have submitted, not considered, all this will be there. If that is recorded anywhere, when it is challenged, at that time, that particular, because you have the other acts which says that your mediation process should be fair. So mediation process should be fair. That is why mediator always have to listen this side, see the evidences, record, and there is a process involved. You have to do it. How do you do it? This act is very small. You have rules and regulation. So far, rules and regulation hasn't come. How do you do the mediation? What is the process? What is the documentation? How do you call for a meeting? How do you conduct a meeting? Whether the meeting can be conducted in record, online can you conduct? Can you record that meeting? All these are not there in the act as of now. That will come in rules and regulations. Rules and regulations. Rules will be prescribed, regulations will be specified. The process of conducting mediation. Because it says process. What is the process? So, how many days notice you will give? Now, once a meeting is conducted, within how many hours or days, minutes has to be circulated. Now, the minutes has to be confirmed. These are all there. So, whatever you are mentioning about going back, this record, once it has been created, going back is not possible.
Correct, sir. Going back has no option. So one very silly question, sir. Sir, does the Act specifically mention the chartered accountants who are eligible to do the mediation?
I really appreciate this point. So, for that, I want to take you to a term called mediator. So far, we have only discussed about mediation. The
Who are the
person is
mediators?
called mediator. Person is called the mediator. Now I am coming for the person. Okay. Mediation
Right.
is a process. Mediator is a person. Okay. I will go to the mediator now. Now look at this word mediator. Now, who is a mediator? So this is your section 3I. Means a person who is appointed to be a mediator by the parties, that means disputed parties, or by mediation service provider. Mediation service provider is an organization. You register as a mediation service provider, MSP. MRP is maximum retail price. MSP, mediation service provider. You register. Now, mediation service provider is an organization. Now, there were qualification, experience, all these are mandated. Okay, so and you register as a corporate, as an organization. So their reference will come and look at this. So by the parties or by a mediation service provider to undertake mediation and includes a person registered as mediator with the council. Now, what is this council? Its council is called MCI. Okay, Medical Council of India? No. Mediation Council of India. Okay. And Mediation Council of India is still not formed. Now, the problem with this is once it is formed, you know who will go and register there? First line lagenge. Hamara chartered accountants will go and register there, and I'm also see this is now. I just want to put this question to Nitin Baradia and my Central Council members also, if they are here, that if whether ICA, let's say there is a law where it says that there is a registered as a tax practitioner with the Council of ICI. And if other than chartered accountants also, if the gate is opened, if people come and that means that there will be so many people who will come and put application. Yes or no? Because no need to write
The
exam.
lawyers, sir.
No need to write exam. Same is the case with them also. So they feel other than legal professionals, they are threat to the legal profession. So it is a backdoor entry to legal profession. Without a BL, without a bar council membership, see, if I as a chartered accountant, I have to become a bar council member, I have to leave certificate of practice of CA. I repeat, I have to leave certificate of practice of CA. And minimum 3 years, I should not practice as a CA. I should not hold COP. I should only practice law, or I should be a junior, or I will be an independent legal practitioner, not an advocate. I'm not an advocate, but I'm a legal practitioner. I practice legal independently. I'm not a member of the bar council. I don't hold any certificate of practice. I don't practice any other profession. Then only I'm eligible to become a member of Bar Council of India as a chartered accountant. And many of our ICA members have become advocates. They are not practicing advocates. How? 3 years. Vanvas liya hai. 3 years of vanvas is required to become an advocate, to become a bar council member. So now you make a mediation council of India and you invite online applications. So zyada people aayenge. And now you will ask a question. Okay, who is a mediator? What is the qualification? Okay, I'm now taking you to a very, very interesting paragraph. This is a research paper, the framework for use of mediation under the Insolvency Bankruptcy Code. This is a report of an expert committee which has been brought in January 2024. And the report is actually submitted to the insolvency. This is constituted by IBBI. And who are all part of this committee? Chairperson is Dr. T.K. Vishwanathan. Sudhakar Shukla, member, Dr. Rajiv Mani, member, Behram Vakil, and Shardul Shroff, the very senior advocate in our country, Sumant Batra, an insolvency professional, Satyajit Rao, Santosh Shukla, member secretary. These team, they have brought it. I will now bring before you the qualification. The qualification which you have asked for. Now look at this. The committee took notice of the common criticism of mediator appointment system by requiring experienced and seasoned experts. They deny young and aspirational mediators. A newly qualified chartered accountant, they want to become mediator. Deny them the opportunity to launch their careers. To end this, the committee recommends the formation of pool of mediators comprising what? Legal practitioners with 10 years of experience in insolvency disputes. Persons with experience as mediators or in mediation advocacy in commercial disputes for 10 years. That is with commercial disputes, I brought it. So, persons with technical expertise in insolvency, accounting, valuation, sectoral and industry operations, possessing experience that is 10 years. Chartered accountants will come into this. This is the recommendation of the committee, the expert committee. So quite an interesting list, but big brothers and big sisters they are in the first line. And, okay, this and, so all three. So legal practitioners, mediators who are already been a mediator. So there are people who don't want to become member of bar council. They don't want to high courts. They only do mediation practice. There are legal practitioners who only do mediation practice. They are not advocates. They are not members of bar council, but they are mediators. So we have such a team. Now I just want to share with you one slogan. This is that slogan I want to share with you. This is from Supreme Court, Mediation and Conciliation Project Committee of Supreme Court of India. Please read this. An ounce of mediation is worth a pound of arbitration and a ton of litigation.
Great, sir.
What a word by Joseph Greenbaum. What a word. Ounce of mediation. So that is why. So can we equate the love and affection of mother to anything else? Because she understands the pain of children. The mediators are like mothers. So the ounce of mediation is worth a pound of arbitration and a ton of litigation. That is why even litigation, you go to court. Arbitration is almost akin to court. But mediation is also ADR, alternate dispute resolution. But that is given the first priority. Supreme Court has given this first priority. And I want to bring before you how many people. This is a 40-hour mediation training program conducted by Supreme Court. And how many people have been trained? Please look at this. So far, there are 839 mediation centers in India. Number of mediators trained so far, 6,480. And these people will come under the category 2. Nitin Bhardiya ji, the category 2 is there. The category 2 are these guys. 6,480. Okay. And the number of cases referred to this, 9 lakh. Settled cases, 3 lakhs. What is this? 1/3 is settled by them. And there are connected cases between them. One case is connected to another case. So, and just imagine if chartered accountants also join this league.
Tremendous. Great.
We are going to create
ample opportunity, sir.
Exactly.
Ample.
If at all, the CA students have been thinking that doing audit, okay, only doing tax filing, representation, litigation, tax litigation, that is the only scope. No. कहां पैसा का dispute है, वहां chartered accountants का role है.
Yes, sir. Moving at, sir, we were discussing about when were we discussing about this role of a mediator or the term of the mediator, the term bankruptcy claim. So, sir, are there any framework for use of mediator under IBC 2016?
As of now, no. As of now, no. But I want to see under the Insolvency Bankruptcy Code. So this is that report. Okay, this is the report. And in India, this is the summary of that report. In India, criteria for mediator appointments will require adoption of a culturally appropriate indication. The committee view that the stage of initial implementation will be very crucial. Given the complex and technical nature of insolvency disputes, committee recommends that a pool of mediators should include retired members of NCLT, retired members of NCLAT, senior advocates, and advocates with experience more than 10 years, and ex-senior officials of financial sector regulators and commercial banks, insolvency professionals more than 10 years of experience. IPs with 10 years, more than 10 years of experience. Of course, IBC Act itself is not 10-year-old act. That means people who are IPs who have more than 10 years of experience. That is what they say. That means other experience will be there. So they are the probable pool, and these are the additional pool. These are the additional pool. These are the probable pool. The pool of mediators is the original list of mediators पे chartered accountants नहीं है. But insolvency professionals, because for IBC mediation, they say insolvency professional 10 years experience required. But the Mediation Act is not only insolvency disputes. But I want to bring one particular case here. Please look at this case. Parvinder Singh versus Intech Capital Limited. This happened in 2019. So on 6th of December 2019, NCLAT gave one decision. See, there is no mediation process in the entire IBC Act. But you will be surprised. Nitin bhai, you will be surprised. National Company Law Appellate Tribunal ordered for a mediation process in the IBC. Oh my God. Is it so? Yes, it happened. This honorable NCLAT allowed mediation plea by corporate debtor. See, there was an insolvency order was done by NCLT. They went to NCLAT. My lord, we don't want insolvency process. हम amicably settle करेंगे. Amicably settle करेंगे. See, this word is very important. When you go to court and my lord, you say, my lord, मुझे dispute नहीं चाहिए. We want to settle it. What the judge will say?
Settle it.
हाँ? Oh, very good. मुझे सर दर्द नहीं है. जाओ. Settle करके आओ. It is not there in section. But look at this. NCLAT was wise. NCLAT was having this forward thinking. So the plea was given by the corporate debtor. Good. They thought this and appointed a retired judge, Shri A.K. Shikri ji, as a mediator. Where is the procedure in IBC? No. There is no provision in IBC. Further, the matter got settled by the parties. This is the plus point. And the mediation report was submitted, settled amicably by being post-dated checks. Wow. What a process. This is not there in IBC at all. But this is an IBC case. The case was filed by Intech Capital as the financial creditor. Under 7, the mediation was permitted before formation of the committee of creditors, and further held that CIRP can be revived by petitioner in case of breach of terms of settlement. So in case, as per the promise, you don't do it, then again you can come for insolvency. On completion of the compliance, application deemed to have been withdrawn. Otherwise, the order setting aside shall be continued. So whatever the mediation is done, do as per the mediation. Settle okay. Then the insolvency order will be null and void. In case, as per the promise you don't do, insolvency order will be valid. This is the case. What a beautiful case it is. Amazing. So, in IBC, mediation has become a practical point. It is not there in section.
Was not in the law as well.
It is not there in rule. It is not there in regulation. This is good. So, that is why mediation is required. Jagada ko khatam karni chahiye. Some method. We need some method. When the law itself was not there, NCLAT facilitated. Now you have the law. And IBC, this framework mandates that let us have a separate rules, separate regulations for inbuilting the mediation process in the insolvency bankruptcy code. So that means scope is still widened. Scope is still widened.
Right, sir. Sir, one more question, sir. That initially you said that all commercial cases, all commercial disputes will be covered under the Mediation Act.
Yeah.
But now I'm putting in another way that what sort of other cases are not covered under mediation? What might be some cases
Good, good.
which I think is a commercial, but other party doesn't think it is commercial, sir?
It's a good question. Actually, this Mediation Act has actually 56 sections only. But you will be surprised, it has 10 schedules. 10 schedules. Okay. Now look at this. This is I'll take you to schedule number 1. This is the first schedule. Disputes not fit for mediation. They are given a very big list. So, what are these? Disputes against minors, dispute against deities, disputes with intellectual disabilities, okay, or rights of persons with disabilities act. Those are all special. You cannot use mediation for that. Disputes involving prosecution of criminal offenses, no mediation there. Complaints or proceeding initiated before any statutory authority, any disciplinary proceedings, no mediation. DC proceedings, no mediation. SEBI, Enforcement Directorate, no mediation. Okay. Relation to registration, discipline, misconduct of any practitioner or other registered professional, such as legal practitioner, medical practitioner, dentist, architect, chartered accountant, or in relation to any other profession, whatever discussion is regulated. Now, why they are not adding cost accountant, company secretary, architect, actuary? They can add it. All are regulated only. Okay. So those will not come under mediation. And matrimony disputes having the right on the right of a third party who are not a party to the mediation, except only in matrimonial disputes where the interest of a child is involved. That can go for mediation. So, तुम पापा के पास जाओगे, मामा के पास जाओगे. Okay, so this kind of thing we can go for a mediation because these are all very soft-natured disputes. Any proceeding relation to subject matter coming under green tribunal. So green tribunal only decide karega because those are environmental related issues, very serious, very serious. Similarly, dispute relating to tax. Tax, no mediation. Okay, because it's statutory. Levy, collection, penalties, okay, direct, indirect taxes, refunds.
So here you mean, sir, when there's SSC and the government, then no mediation.
Nah, the statutory body. The statute, no. So separate section. So no mediation. So investigation, inquiry under the Competition Act. Okay. Telecom Regulatory Authority. Okay. All this. Electricity Act. So Petroleum and National Gas Regulatory. SEBI and the SEBI SAT, SEBI Appellate Tribunal. I told you, no, these are all no mediation. So they are all supreme. Land acquisition, determination of compensation, because compulsory acquisition. Oh, mediation nahi aayegi. Okay. So all these will not come under mediation. Quite interesting list, no?
Yes, sir. Very interesting, sir. Sir, in your earlier this PPT, you have shared about the mediator council. Sir, is there any mediation institute as well as of now?
Yes, it is there. So I just want to, this is called Mediation Institute. Okay, so this is quite an interesting topic. So I'm sure, like ICAI, IMAI also may come, Institute of Mediation Authority of India, or Indian Institute of Mediation Authority. So it is a body or an organization purpose is training, continuous education, certification of mediators to carry out. But this is being defined, rules, regulations, structure, formation, the government will decide. Okay, so we have to wait for the institute to be formed. So look at this. Holding.
Sir, from the definition, we can get an idea that even ICI can also appoint a panel of experts like you who can train the members, and they can ICI itself can give a certificate, sir, like that. Like we have a valuation certificate, sir. It's been
Absolutely.
organized
What you
by
said is
ICI.
absolutely correct, because Section 42. The
Yes.
council, that is the Mediation Council of India. Okay. So we have the mediation, the council means mediation council, shall recognize mediation institute to perform such duties and account. So that is why already ICS provide ICA panel of mediators is there. Panel of media arbitrators are already there. Now they have to go for a panel of mediators. Now look at this panel of arbitrators. Now whether they will convert this to panel of mediators, we don't know. But we already have a panel of arbitrators.
Okay, sir.
Better to have a panel of mediators also in this. So this is panel of arbitrators. So this is high time that ICA should go, and we'll request Dr. Rohit Ruvatyaji, CA Dr. Rohit Ruvatyaji, Chairman of a Committee for Members in Practice. Kindly go ahead to have a separate portal to invite applications with the same 10 years criteria. Is already there, 10 years criteria.
The IBC it is there, sir.
It's
And
already there.
definition also you have mentioned that
Yes,
about 10
it's there.
years.
So ICA can akin to that, can actually sync with that criteria and invite, and we can have a panel. And another some 8,500 pages of the ICA panel of arbitrators will zarur aayegi.
But sir, in that definition, it was written that technical experts,
Yeah.
the person who has sound knowledge of accounting, taxation, like that, was written in that definition.
I'll show you. This one. You mean is
Yes.
an additional tool?
Yes, technical expertise, it was written.
Persons with technical expertise in insolvency, accounting, valuation, sectoral industry operations processing experience of at least 10 years. So
Yes, after 10 years. So 10 years they have to. Right, sir. Sir, as you said that I think rules are not at all prescribed. Rules are still under forming and it's not prescribed. So, sir, for beginners like us, how can we proceed if somebody comes here and though we have a degree of chartered accountancy with us. So, can we start it, and how we can proceed, sir, until the rule comes? Then how you can suggest from your experience that how we can proceed for this
well,
mediation?
as of today, I showed you this Supreme Court. This is one thing which they conduct. Mediation and Conciliation Project Committee. So here they conduct this 40-hour training program. So the MCPC initiated a court integrated mediation process. Look at this. That to Supreme Court. Okay. Encouraged by the result, the MPC has conducted 40-hour mediation training program. Then training of trainers, how to conduct training, they conduct training. Awareness program, referral judges, training program, mediation, conciliation project committee has conducted following since, the different till 2015. And after that, we have another 9 years have happened. So it would have gone double of this. And so far 147 expert trainers are there in various countries also. So this is one, I will say, the highest level of mediation training area. And this 40-hour mediation training program is such an important training program. And whenever Supreme Court Mediation and Conciliation Project Committee, they announce such a training program, I wish chartered accountants at least be part of this and get trained. And we'll also be part of this 147. And then we trainers can train our members. So that is how the legacy. So now our grandmother knows how to make vegetable biryani or mushroom biryani. Then how the daughter will know? Grandmother has to teach. Then the mother will teach her daughter. Like that only legacy will follow.
Correct, sir. Very truly said, sir.
So
So a lot of scope.
we'll find out whether any questions are there from participants, sir. Else we can we can wind up also as early as
Yes, sir. I have seen, actually, I was checking that questions only, sir. You have explained in such a great manner, sir. You have covered each and everything, sir. So no questions are there, sir.
okay.
So it
Yes.
was such a lovely interaction with you, sir.
Thank you.
It's my
Thank you.
pleasure to moderate this session like this with such a dignitary like you, sir.
It's my pleasure. I'm whatever little I know about. I'm also exploring a lot in this particular area. So slowly, I'm also getting to get a grip of it. But I see a flurry of opportunities that can open up, and only thing is, chartered accountants should have that openness to have it, and we can every CF firm can offer a bouquet of services.
Right.
So that one of the bouquet, one flower will be a mediation. So one
Correct,
of
sir.
the partner will be a mediation expert. So one partner will be an valuation expert, one partner taxation expert, one partner financial reporting expert. This is how the amalgam of or the combo of a CF firm I see in the coming years forward.
Correct, sir. Truly.
So thank you very much, Nitin Bharadiaji, for being part of today's program and being a moderator and coordinating this program. And special thanks to CA Dr. Rohit Ruhatia also for enabling such a program and making it a no-fee program so that
Yes, sir.
members at large can participate and also get their due CP credit along with a knowledge update on the latest development. So we should appreciate the initiatives of committee of members and practice for these kind of initiatives, and we'll be supporting wholeheartedly the initiatives of ICI with respect to these kind of initiatives. Thank you very much, Nitin
Thank you,
Bhai,
sir.
and over to you for your
Thank you, sir. Thank you so much, sir. Thank you. Thank you so much.